Criminal Procedure Identification Act 2022 and the Prisoners Identification Act 1920, a comparative study. We all know the Prisoners Identification Act 1920. It happened during the British Raj, and the technology was not that much updated. So whatever it was feasible during those days, that sort of data pertaining to the convicts have been mandated by the act to be collected by the police officer after his conviction. But today, the NDA regime, particularly Sri Modi ji's government, has brought a new act called the Criminal Procedure Identification Act 2022. What is so special about this? And today we all make a big campaign that we wanted to get out of this colonial legacy, we wanted to improve because we have a constitution now, all these things. Whether this act is an improvement over the earlier act, that is the British Act, the answer is simply no. At least during the British Raj, they can have an excuse that there is no constitution what is existing today. Today you have a constitution and which clearly prescribes and recognizes and enforces the fundamental rights. And fundamental rights guarantees certain safeguards. And that safeguards can never be violated by the state in any sort of circumstances. It is called non-derogable clause. In the non-derogable clause, Article 20 and 21 comes into picture. Always, please remember that. Article 20 and 21 cannot be suspended even during emergency. Even during emergency. This has been made explicit by this Parliament after Justice Khanna's judgment in the ADM Jabalpur case. But I'm afraid that safeguards are slowly eroded through various so-called special legislations even during the normal times. And unfortunately, courts are also not taking into this serious prejudices into cognizance. This is very unfortunate. Instead of acting as a guardian of the fundamental rights, the courts are also simply sitting upon those things. They permit it. Example, the bail clause under UAPA. Doesn't mean that we say all the circumstances Supreme Court is acting like that. There are some judges. Yes, they have the guts to declare that these sort of provisions are unconstitutional, but there is no consistency in this approach. This is very saddening one. Now, coming back to this particular act, why it is raising serious prejudices? You have a right to collect the data about the convicts. There is no doubt about it. But this act goes beyond it. This act mandates the police officer to collect cases pertaining to three classes of persons. Any arrestee, any person who has been arrested by the police officer. This is a very serious one. Next one, any person who has been convicted, okay, with which people may not have a big problem because he has been convicted, his records have to be processed and maintained. The next one is again politically and constitutionally problematic today. Any person who has been detained under the Preventive Detention Act. If this is something preventive detention, if it is pertaining to terrorists, something like that, this is people may not have any big objection. But today, even for any political strike, hartal, bandh, people are kept under preventive detention sometimes. So this is raising serious alarm. So three classes of person comparing with the old act. Old act says only about the convict. The new act says any person who has been arrested by the police, then detainees kept under preventive detention, and the convicts. So these are the three classes. Okay. Who can collect the data? The previous act, say the British Raj Act, says any police officer not less than the rank of SI or SHO, station head officer, is empowered to collect this data. The new act even lowers that safeguard. It says police officer means any police officer not below the rank of head constable. This is raising yet another, because head constable is not that much experienced, he may not be well equipped. At least SI considered to be the head of the station officer, therefore he can be empowered. That is why this is the procedure even adopted way back in the CRPC long time ago. Even that standard has been lowered or erased, brought down by this act. Then what sort of data can be collected? Again, there is a big difference. In the old act, only three sort of data can be collected pertaining to the accused or convict, whatever one may call it: photograph of the convict, footprint of the convict, fingerprint of the convict. But today, since the technology has grown up, so all these data are collected. Again, in addition to the aforesaid three things, the new act empowers the police officer to collect the following data. That is, addition to the photographs, fingerprint, footprint, farm print, then behavioral attributes. I will come back to the behavioral attributes a little later. Then physical and biological sample. Now, what constitutes physical and biological sample has not been explained in this act. It simply states, for collecting the physical and biological sample, the procedures laid down under section 53 and 53A of CRPC have to be meticulously followed by the police officer. Now, what is section 53 and 53A of CRPC contemplates, that one needs to look at it. Now, section 53 speaks about medical examination of the accused. Who should conduct the medical examination? If it is any registered medical practitioner, preferably the government doctors, are empowered to take the medical examination of the accused. It also provides certain safeguards to the women accused. When women is being subjected, medically examined, then such a process has to be conducted under the supervision of a female registered medical practitioner, and it has to be done under the supervision of the female police officer. This is very important. Additional two safeguards. This is general circumstances. Whereas 53A is a new one. This has been enacted specifically to deal with the cases pertaining to the rape. When the rape accused is examined, what are all the procedures to be taken and what sort of samples shall be taken up? With which we have given a very detailed video about the process of collecting data or evidence pertaining to the rape or medical examination of rape victims and accused, all these things, in a separate video. Please follow that. Okay. So, what constitutes biological sample? You all know: blood, urine, then sputum, right? Ovaries, many things. So, ordinary things like nail, hair, many things. Apart from DNA testing, even the present act, present government wants to constitute a DNA bank, which is already taking place. They wanted to have certain repositories, all these things. Then behavioral attributes. This is a very serious one. It simply says like signature and other sort of things can be taken into account. We are afraid whether the behavioral attribute can be widely interpreted so as to include the lie detector test, FRT, facial recognition technology, all these things. It's doubtable, because already these things are implemented without backing up of laws. So we are not sure, but please note that lie detector test and other things, polygraphic test, all other things have been declared unconstitutional way back early in 2000s by the Honorable Supreme Court, by a constitutional bench under the leadership of Sri K.G. Balakrishnan. in Selvi versus State of Karnataka. So people afraid whether that constitutional safeguards will also be taken away or seriously prejudiced by this new act. Then we have already discussed whose data can be collected, which police officer can collect the data. Then apart from that, there are other two persons are also eligible to give directions to collect the data. One is executive magistrate. This happens during the security proceedings, what they call it under the CRPC, keeping of good behavior, security, all these things. That is executive magistrate. The next one is judicial magistrate. Judicial magistrate can also direct the police officer to collect the data pertaining to the offences conducted or proceedings conducted by him if it is necessary. The next one, refusal of giving data by the arrested person per se is an offence under this act, and it empowers the police officer to use reasonably lawfully the reasonable force to extract the data. This is where people afraid it hits Article 20, Clause 3. Mere taking photographs, footprints may not violate, but when you conduct DNA analysis, all these things, it has to be done with the permission of the court. That's what people believe it, because some constitutional safeguard must be there, and that too, when you empower the head constable level, it may lead to serious prejudices. This is the problem. Then, magistrate is empowered to do so, to collect all this data. Executive magistrate is empowered to do so, to collect all this data. Then they are given some safeguards to the classes relating to the arrested persons. It's not persons who are simply arrested. Any person who has been arrested for an offense which is punishable not less than 7 years, and cases relating to women and children shall be subjected to taking of measurements, whereas others may, that's what the word is used, so may again be read as a shall by the police officer, because they may not know the difference between may and shall. So irrespective of these differences, though the statute gives certain differences, but ultimately practically police officer may not know, so they may collect the data irrespective of these statutory safeguards given to the other persons who have been convicted or offences which is punishable less than 7 years, something like that. So this is another problem. So these are the some key provisions pertaining to these offences. For comparing the following things, the Prisoners Identification Act is a pre-constitutional law. The 2022 Act is a post-constitutional law. The Prisoners Act empowers only the SI and to collect only three data, that is photograph, fingerprint, all these things. The new act empowers SI as well as head constable, and it empowers to collect many data apart from photographs, all other things such as physical sample, biological sample, behavioral attribute, all other things. So the quantity as well as quality varies. The next one is under the old act as well as new act, magistrate as well as judicial magistrate as well as executive magistrates are empowered. But in the new act, less than 7 years constitute a separate category. Punishable offences less than 7 years constitute a separate category. In the old act, there is no such differences, because any person convicted more than 1 year per se is subjected to collection of data, all these things. Whereas in the new act, there is no difference between convicts and non-convicts. Okay, all of them are subjected to taking of measurements. Whereas in the old act, it deals only with the convicts. That is a big difference. Then in the new act, the Data Protection Act has come into picture. That is silent. Whether that procedures laid down under the Data Protection Act has to be followed. Such a act was not there during the British Raj, so therefore there is no, it is not at all applicable. Next one is that who can maintain this data? That's very, very important. It for the central government, it empowers the National Bureau of Criminal Records to follow maintenance of the records, storaging, processing, disseminating all these things. Whereas it empowers the state governments and UTs to prescribe their own agencies. Sometimes if they outsource this, again this may be very serious one. These sort of things is not at all applicable to the old act because it is silent about it. It doesn't speak about all these things because it is not prevailing those days. Apart from that, another criticism which is not applicable to the old act but applicable to the new act. The Juvenile Justice Act provides certain constitutional safeguards to the juvenile convicts. Okay, because there is a principle called fresh start, right to be fresh start. That is not explicitly addressed in the new act, that is 2022 act. This is not applicable to the old act. So this has to be clarified either by a Supreme Court judge benchment, or at least they could have clarified in the form of proviso or explanation, something like that. This is a very serious issue because at the time of arresting, they may not know who is a juvenile or non-juvenile. So this is a very serious one. The next one is time limit. The old act doesn't speak about it explicitly, but the new act speaks about explicitly the duration of protection of these records or maintenance of these records for 75 years, almost for 3 generations. These records will be kept. So this is again a concern raised by many critics. So these are all the important comparative aspects. And in the old act, Article 20, Clause 3 argument will not come. For the new act, Article 20, Clause 3 and other safeguards given under CRPC 53, 53A will be applicable. It not be applicable to the old act. Apart from that, other judicial decisions such as Selvi versus Seat of Karnataka will be made applicable to the new act, may not be made, shall not be made applicable to the old act. Thank you.